Good day, everyone. It's May 13th, 2025. My name is Eric Olsen, Executive Director, founder of Helps. Helps is a national law firm that we have two missions. Our first mission is to protect seniors from collector harassment. Our second mission is to educate seniors how they can maintain their financial independence. And the title for today is Seniors Don't Be Afraid of Debt. And I'm going to just talk about that at the beginning, then I'll get to your questions on the chat. And if you're first time here, I want to welcome you. My name's Eric. I've been an attorney now for 46 years, founder of Helps. And I want to give you the reasons why your Social Security is protected, why you don't need to be afraid of debt. Number one, your Social Security is protected. No one can take it, okay? It's available for your needs. It's not going anywhere. If you owe debt, a creditor can't take it. Even if they sue you and get a judgment, they can't garnish your Social Security. That includes also your pension, okay? And other forms of retirement income like a 401k or an IRA. They're also protected. Social Security has been protected ever since its inception in 1935, 1936. Pensions are protected too. There's a federal law called the Employment Retirement Income Security Act that protects a pension. If your pension isn't protected by that federal law, there's a state law that protects your pension. Now, the other thing that you need to know that if someone were to sue you and get a judgment, that the money in your bank account is protected. There's a federal law went into effect in 2012 that protects twice the amount of monthly, automatically by your bank, twice the amount of monthly benefits you get from Social Security or another federal source from garnishment, regardless of what other funds are in there or where they came from. So if you get $1,500 in Social Security, $3,000 in your bank account is protected automatically. Another thing why you don't need to be afraid of debt. Federal law passed in 1978 called the Fair Debt Collection Practices Act. It provides how you can be protected from debt collector harassment by phone calls or demand letters. Okay. It also provides that if you're represented by an attorney, debt collectors can no longer call you or send you demand letters. They have to communicate with the attorney, and that's what Helps does. We represent seniors nationwide, all 50 states, who have debt they can't afford to pay in order to stop collectors from bothering them. They find out about us, they call us, we talk to them about our program. We don't turn any senior away that qualifies for our help. When you enroll, you give us the creditors you owe money to that you don't want to pay anymore, that you don't want to hear from. We send them a cease and desist letter, and they have to leave you alone. And it doesn't matter where you are. Maybe 1 out of 5 of our clients is being sued. Maybe 3 or 4 out of 5 are being harassed by creditors, but 1 out of 5, they might be completely current on everything, but they finally realize they can't pay their debt anymore. It doesn't matter where you are. The other thing why you don't need to be afraid of creditors or debt collectors or debt is you can always call Helps with your questions, no matter how often, okay? We're here to answer your questions. If you're sued, you're not going to need to go to court. If you owe the debt, you don't need to go to court. If they sue and if they get a judgment against you, your Social Security is protected, as your pension is protected in your bank account, so you don't need to worry about a lawsuit if you owe the money. Now, if you want to defend the lawsuit, you can, but you don't need to. You don't need to go to court. So when clients find out about Helps and if they're sued or if they have a question about a lawsuit, we're going to explain to them why their income is protected, why you don't need to worry. Okay? One of the things we're going to tell you is that you're judgment proof, which means even if they sue and get a judgment, they can't collect from you. Okay? Because your income is protected. And I already explained how your bank account is protected automatically without you having to do anything. Okay? Twice the amount of your federal benefits deposited in your bank account is protected automatically by your bank without you having to do anything. Now, your bank manager probably doesn't understand that rule, but there's a department in the bank that understands that law. And I've always said, and I'm not going to change it, probably 999 out of 1,000 attorneys don't know this rule. It went into effect in 2012, but a lot of attorneys don't practice in this area, so they don't understand that rule. How twice the amount of your income that comes from Social Security is protected, regardless of the source of funds. Okay? But you don't even need to worry about that unless you're sued. But then once again, if you're sued, you don't need to worry about it. Okay. Now, if you have other assets like a home or a car, furniture, household goods, there are state and federal laws that protect your income. Okay, and protect the state and federal laws that also protect your assets. They're called exemptions. So you don't need to worry about them coming and taking your household goods or repossessing a car or trying to take a car. Now, obviously, if you owe money on a car and they have the title, then that's different. But if you have a creditor, a judgment creditor like a credit card, it's not their practice to try to take your car. Even if you have equity in the car, if it's worth more than what you're allowed to keep under your state exemptions, okay? Creditors just don't do it. They don't go after those assets. They don't try to attempt those for a lot of different reasons, okay? And then our final message is, things work out. I've been an attorney now 46 years, probably filed between 30 and 40,000 bankruptcies, and been in started helps in 2012. Things have a way of working out. Okay, you can listen to what we talk about today and every day at the same time for an hour. We have this YouTube live session, and you can also call us on the phone, toll free, 855-435-7787. 855 helps us or helps us, and you can put questions in the chat feature, and I'll address them. And it looks like there's a number of questions already, and I'll get to those. And then I have a lot of other things to talk about that will help fill out the today. But don't want you to worry. Okay, and Mary, do we have a video about selling your home and moving to assisted living? No, we don't. That might be a good one for us to think about doing. Okay, but we do talk to people about selling their home. What to do in that instance or how that works. So Danica asks from Baltimore, I received a letter from Discover that states they require my consent to receive information from the IRS and want me to sign an Equifax verification. Well, I don't, do they have a judgment against you? I don't think you need to sign that. Okay. No, I don't know. That's, Discover, their attorneys sometimes are really active on trying to collect debt. But don't let that intimidate you. Remember, your Social Security is protected, so is your pension, your disability. They can sue you till they're blue in the face, but they can't, you're judgment proof. They can't collect from you. There's no reason why you have to give them permission to get additional information from you like they're saying here. No. I've never heard of that before, frankly, from Discover or any other creditor trying to get information directly from the IRS. Now, maybe they want information to verify your income. If you're an active credit card holder, that could be, okay? I could see that. But if you're behind and not paying them, then they have no right to get that information. But if you're an active credit card holder, that may be something new that they're doing to verify information, because they can do a soft pull on your credit report. They can't do a detailed pull on your credit report, and they may want us to look at that to see if they want to continue having you as one of their credit card holders. So maybe that's what they're doing that. Pretty aggressive on their part. Okay. Deandra asks, I have Social Security, also a pension from California Public Employee PERS. Is that pension protected? Absolutely yes. No one's going to be able to take it. Okay? Now, remember, twice the amount of your federal benefits deposited in your bank account is protected from garnishment. You don't even need to worry about that unless you were sued. Okay? If you happen to have more than that in there, let's say you got $1,500 in Social Security and $2,000 in CalPERS. and let's say someone sued you and got a judgment, and they happen to file a writ of garnishment, they happen to know where you bank, which is not easy for them to find out. If they happen to garnish your bank account and you had more than twice the amount of your Social Security in there, more than 3,000 in there, uh, yeah, there's paperwork you can file, a challenge to garnishment or claim of exemption, depend on the state, and um, the court will then order that money be released to you. When that happens to one of our helps clients, it doesn't happen very often. We'll tell the client how to fill out that form. You know, we'll give them that information, and then we'll reach out to the attorney that filed the writ of garnishment and give them that form that you filed with the court, and say, will you go ahead and release this money earlier, so that rather than having the client have to go to court and show this to the judge. And vast majority of times they're going to agree to do that. So no, you're not. You don't need to worry, Deandra. Your money's safe. Okay. Okay. If you want to pay your debt and can do it, can you recommend how you can find a legitimate debt management plan? What criteria would you recommend for judging a legitimate debt? I don't know if any of them are legitimate. Maybe a few. The legitimate ones will refer someone to helps, and there's not very many that do that, but a few do. How do you know if it's legitimate? If you called them about your problem and you were a senior and they never told you or never asked you what your source of income was, and if they knew that you were older and you were on Social Security, if they never asked you, by the way, uh, all your all your income is protected, it can't be taken from you. Okay, if they withhold that information, I don't trust what they do. Now, if all your income is protected and no one can take it from you, okay, then why do you need a middleman to pay your debt? You can pay your creditors however you want. If it's a matter of you feeling guilty about it and wanting to pay someone and you have the extra money, go ahead and do it. You don't need a debt management company taking a quarter of what you pay or more to pay the debt. Instead of paying them, you can pay it yourself. Okay. Um, John Kemp says, I understand that 2 times the monthly benefit is protected automatically. I have about 10,000 more than that. It's difficult to get that extra protected. We'll have to go to court and get a lawyer. Um, well, if the money came from a federal source, 2 times is protected automatically. If you have more than that, then you don't need to worry about it unless someone were to sue you and get a judgment. And then you had that money in an account, and if they filed a writ of garnishment, the excess could be held up. One way you can prevent that from happening is just pull it out when it hits there. Put in a preloaded debit card, cashier's check, money, cash, whatever. So you don't have more than two times the amount of your federal benefit in your account at any one time. So if the money hits there uh, on a Friday morning, you can pull it right out, or Wednesday morning, and then the garnishment would have to hit there right at the exact right time when the money was in there over twice the amount. So you could pull it out. Then you wouldn't have that problem. But you don't even need to worry about it unless you were sued and someone has a judgment. And then it's not really easy for a debt collector who has a judgment to find out where you bank. There's no place they can go to find out where you bank, unless you bank there a whole long time, a lot of time. Okay. So Miss H says, after a client of helps has been with you for a year or more and they pass away, if a creditor starts contacting the children or try to sue for money, will help still help? Absolutely. What we tell people is, if someone passes away, and we get calls occasionally from a spouse or from kids saying one of our clients passed away, okay, and they'll want to know what to do. What we tell them is to, when your parent or your spouse uh, was was passed away, the funeral home will give you maybe half a dozen or more copies of the death certificate. Well, you can take one of those copies, or you can make a copy, and if you get a bill from a creditor that's a bill for the deceased relative, then you can attach that to the bill, send it back to the creditor, and write on there, if it's the case that there's no estate, no assets, no estate, and write your name down there and send it back to them, and then they'll know that there's nothing they can do to collect, and that will be the end of it. Eric, can you talk about Care Credit of Synchrony Bank if I have to turn in? Have you dealt with them? Well, Synchrony Bank, I don't know if they even have local branches. They probably do, but they back a ton of credit cards. Okay, different credit cards, and I guess Care Credit is one of them. So what that means, if someone calls and with helps, and we're going to ask them, if they want to keep a credit card that's a smaller balance, and we explain it, you can keep that credit card as long as it's not backed by a bank with whom you have another credit card you're not going to pay. So someone may have like a Care credit card that's banked by Synchrony Bank, but if they have another credit card that's backed by Synchrony Bank, and they're not going to pay that one, they're going to turn that into helps, then the Care credit card would be cut off. Okay, so but if you only had one credit card with one bank and you keep paying that, you could keep that credit card. Okay. I hope that answers your question, Kat. If not, you can ask it again. Thank you, Linda. Um, okay. Okay. So here's a question that comes from a client or someone. It says, hi, this is, he puts his name. I'm 65, received a letter from a law firm representing a creditor that I may be sued for a debt. Okay. I think we talked about that yesterday. But I'll mention this. This morning I talked to a person, I think from Florida, and she called about helps. And the reason she called us is she got 3 or 4 letters from different law firms telling her that she was being sued. And she hadn't got a copy of paperwork yet, but it scared her, and she went down to the courthouse and found out, sure enough, she'd been sued. And she found out about helps, and called us on the phone. I explained to her that the reason she got the letters is there's certain bankruptcy attorneys that subscribe to a service that lets them know if someone's been sued. And they'll send an advertisement letter, and it's not unusual for you to get a letter from a bankruptcy attorney advertising their services before you've even been served with a summons and complaint. Now, that doesn't mean you have to file bankruptcy. You probably don't need to. If your only income, Social Security, a pension, disability, VA benefits, you don't need bankruptcy. Bankruptcy is expensive, complicated. A lot of seniors don't want to go through that. Okay, and I know I filed between, like I said, 30 and 40,000 bankruptcies before helps was started. The reason I started helps was because some seniors were coming into me and they couldn't afford bankruptcy, or they didn't want to, and helps was a way to protect them from the creditors bothering them without the need to file bankruptcy. Okay. So that's what so this person, I noticed this was from a question on one of our YouTube videos, or it could have been from Senior Living, that helps does with Senior Living. The guy writes in and he says, what about paid off cars? Can they take it? Well, theoretically it's possible, but as a practical matter, it virtually never ever happens. Okay, I'll read you what I wrote, and then I'll talk about it for a couple more minutes, or a little bit more. It said, I wrote back and I said, on the response, I said, state law protects a certain amount of equity in a car. Depends on your state. However, even if you own a car worth more than allowed under the state exemption, it is not the practice of consumer judgment creditors to attempt to execute or take a person's car. They simply don't do it for a number of reasons. And what could the reasons be? You don't have that much equity in it. Maybe you own it with someone else. It's expensive to repossess a car. You'd have to hire an attorney. Different states have different procedures. Sometimes they have to get a bond, and then if they sell the car, they have to pay you your exemption, and there might be an underlying loan on the car. They'd have to pay that. If they do it once, they're never going to do it again because they'll realize they never made any money at it. Okay? We had a helps client, I don't know, in the last 6 months, it could have been maybe longer than that lost a car, I forget where at, to a credit union. And I remember reading the facts on the case, and I told the client, I said, yeah, they did it. They're going to have to pay you some money for your equity, but I'll tell you one thing, they'll never do it again because they're not going to make any money at it. It cost them way more than whatever they were going to try to collect by trying to take your car from you, from taking your car. But please don't worry about it. It just doesn't happen. We've got tens of thousands of clients that helps, and it just doesn't happen. And a creditor that gets a judgment, it's not their practice to go after your car. And the same thing goes for a home too. They just simply don't do it. So John is asking, is it better to keep my bank account below 2 times the protected amount and put excess funds somewhere else to avoid having to deal with courts to get the money released if garnished? Yeah, it is, but you don't need to worry about it unless you were sued, John. If you're sued, doesn't mean they can do it the next day. They have to get a judgment, and that might be several months away before they would ever get a judgment. And it's so easy to keep less than twice the amount in your bank account. Now, I suppose after a year or two, when it gets really stale, the creditor might forget about it, and you could keep more than twice the amount in there, and the chances of them trying to garnish your account is probably pretty close to zero. But if they were, once again, you can file a challenge to garnishment or claim exemption and order the money released. But it's kind of nice not having any of the money held up. And it's pretty easy. Why do you need more than one bank account? Okay. Some people have a savings account. You draw so little interest on it, if you have to have a savings account where the bank, just put the minimum amount in there, $5, $10, $15, $20, whatever the minimum is. Okay, the Chafins ask, my husband is also on Social Security and a private pension. Are both pensions and Social Security protected if just one of us is sued for a credit card debt? The answer is yes. Okay. So let's say your husband gets Social Security and a pension. And you're the one that's sued. The wife is sued. Okay, but you're on his bank account. Twice the amount of Social Security in the bank account which you're on is protected automatically from garnishment, regardless of what funds are in there by your bank. It doesn't matter. It doesn't have to be your Social Security. It could be anyone's Social Security. Same with the pension. And the pension's in there. It's protected not automatically if it's deposited in that account which you're on with your husband. If you had more than twice the amount of your Social Security, what you get in Social Security each month in there, and they garnish the account, yeah, the excess could be held up, but then you can file a claim of exemption and show the court that the money that was in there came from a pension which is protected. The court would order the money be released. So, N. Delazar asks, there's been a default judgment against me for 6 months. No one has asked about my finances or assets. Do you think they're just busy, or will I eventually be asked for this information? Well, if you're a helps client, when you when you got sued, we sent a letter to the attorney to let them know that your income was protected. And they just may have eventually just got a default judgment because that's what they do. And they figure it's a waste of their time to try to contact you, make any attempts to try to collect the debt. So that's probably what's happened. They're not going to worry about it. It's not a matter of them being busy. It's just they realize they can't. They probably realize maybe they've read our letter and they realize there's nothing they could do to collect. Will I eventually be asked for information? I mean, it's possible. Possible. Kind of unlikely, but it's possible. But once again, if you ever are, call helps and we'll explain what to do and why you don't need to worry. We may ask you to send us what you got so that we can look at it. Bottom line is you don't need to worry, okay? There really is no worst case scenario. So Larry asks, if I have a judgment and I pass away, can they take it from my son, my family trust fund? Main asset is the house with equity. It depends how the trust was set up, Larry. The trust might have a provision that at your death, before the trust assets are distributed, that your debts need to be paid. And then in that event, technically your son is required to pay the debts under the terms of the trust. Sometimes people with a home, and if it's their only asset, they may choose to maybe not use a trust. They might choose to add their children onto the house's name as joint tenants with survivorship rights. That means when they pass away, home would automatically go to the kids. Or you might have what's called a ladybird deed. I think 7 states allow that. And the ladybird deed is kind of like a survivor deed, but it allows you to change it during your lifetime. But under that type of deed, at least in Florida, when you pass away, the property would go to the survivor. None of the debt would need to be paid. So it kind of depends on your state and the law. Okay? How common is the debtor's exam? It is so uncommon that I don't even like to talk about it. Brian, that's how uncommon it is. Because for some reason that word strikes fear in someone's heart when they don't need to be fearful. So I try to avoid it if I can, because I don't want people worrying about something they don't need to worry about. Although we do tell people about it. If you we advise people to have been sued. If you later get a paper saying you have to come to the court at a certain date and time, this isn't for a lawsuit to get a judgment, but after a judgment that's signed by a judge, then we want to know about it, because then what we'll do is reach out to the attorney who filed for that debtor's exam and let them know that your income is protected, and do they really want to go through with the debtor's exam because you don't have anything they can take. And the vast majority of the times they're going to agree, okay, we don't need to have the debtor's exam. So we help on that. Sandra asks, what if someone is in debt consolidation for credit cards, I guess, Social Security only income? If I drop the program and pay them, what can they do? Can they sue me? Are you talking about the debt consolidation program? No, they wouldn't sue you, because all they do is consolidate your debt and pay someone else. They're not going to sue you. But if your only income is Social Security, the question I would ask you, Sandra, when you enrolled with them, did they tell you that your Social Security was protected and that you didn't need to pay the debt? And if the answer was no, you weren't given complete information. That tells you a lot about what's behind these companies. They look out for their financial interest, not your financial interest. And if your only income is Social Security and you're struggling, you don't need to pay them anymore. You can stop. And you call them on the phone and ask them to return any money they're still holding for you. I used to tell people, I guess I still do sometimes, tell them, why didn't you tell me when I enrolled with you that my income was protected? That I didn't need to, I've been cutting back my heart medicine, or I've been going without heat, or going without food. People have told me that are enrolled with debt management companies, even the nonprofit ones. Either one, profit or no nonprofit, they're the same. If they told you the truth that your income was protected, you would know you didn't need their help, and you wouldn't enroll with them, and they wouldn't make money. So they look out for their own financial interest and not your financial interest. So Ms. H asks, so if the husband and wife have a joint account and all their Social Security, pension, and retirement is in one account, and it adds up to a big lump sum, is it all protected? Well, if you have one bank account and two Social Security comes in, twice the amount of Social Security, even if there's more than one Social Security check that's coming in there, if someone sued you and got a judgment, and then they tried to happen to know where you bank, which isn't that easy, but if they happen to know and they garnish your account, your bank technically has 48 hours. They do it quicker than that normally. They examine your account and they can see where the money came from. And it came from a federal source like Social Security, a VA pension, railroad retirement, Office of Personnel Management, like a federal employee pension. Whatever that federal benefit is, they times that times two. No matter how many different accounts go in there from a federal source, that amount, twice that amount you get each month, is protected automatically. So that big lump sum is protected, yes. Okay? Automatically. It doesn't mean that if you have more than that it's not protected. It's still protected, just not, the excess is not protected automatically. Would the credit card companies sue me? I don't think they told me my Social Security. No, a debt collector will never tell you what your rights are. They'll never tell you, oh, you don't have to pay us. We're American Express. You don't have to pay us because your only income Social Security. No, the only thing a debt collector or a creditor has to say is, we're a debt collector. Any information you give us can be used for that purpose. Creditor doesn't have to tell you that. No, they don't tell you that. No. They're not going to tell you that your income. If they've told you that, you'd realize you didn't have to pay them. So they're not going to tell you that, and they don't have to tell you that. Could the credit card companies sue me? They could charge me a ton of interest if I try to pay them off on my own. Well, yeah, they could sue. Doesn't matter if you're sued. They can't take anything from you, as we've explained. And it doesn't matter what interest they charge. Now, in most states, if they sue and get a judgment, there's a statute of limitations. Some states it can be extended, a statute of limitations for how long the judgment lasts. But no, you don't need to worry about a lawsuit. Okay? How do credit card companies get by with charging such obscene interest rates, and why hasn't that been challenged? Well, as you can imagine, credit card companies are owned by who? Banks. Banks have a lot of money. They can lobby and they can prevent any legislation that would limit the amount of interest they charge. And what they're going to say is that, if you limit us on our interest rate we charge, then we're not going to give people credit. And so, what's happened is the federal government is kind of leaves it alone. They don't deal with it, and they leave it up to the states. And some states may limit interest on credit cards. In fact, if you look on the back of your credit card statement or a credit card application, sometimes they'll have a state and they'll have exceptions. They'll have a state with a certain exception that they can only charge this amount of interest or something like that. But then, got to understand, if that were the case, then Credit card company may be less likely to give someone a credit card if they were worried about it. The other reason they charge high interest, well, they want to make money. People are willing to pay it. Okay, that's what it's all about, making money. But you're right. The interest rates are obscene. I will have bad credit on now from now on if I quit paying. Correct? Hard to know what to do. I could definitely use the money. Not correct. Okay. Helps has a program for people that have been part of Helps for more than 90 days. It's called 7 Steps to a 720 Credit Score. You can listen to a video on our website, on our YouTube page that talk about, on our regular YouTube page that talk about this program. Might have to scroll down to find it. I talk with Phil Tyrone, which I promise you I'm going to have him on again. It's a program that helps. We started a couple years ago. You can rebuild your credit, okay, within a matter of a year and a half to 2 years. Your credit is based on your recent credit history, and you don't have to pay your debt off to rebuild your credit. Once a creditor or a collector writes off the debt as uncollectible, okay, that they can't collect it. Now they can still try to collect it, but it has a different placement on your credit report. Your credit report is based on your recent credit history. So after you not choose to stop paying your debt and your credit takes a dive, you can start to rebuild your credit from there. And according to Phil, and I believe him, and there's Helps clients have told me so, they've built their credit right back up to over 700, even though they may still have debts they haven't paid. And even if they have judgments, the credit reports don't show judgments on the credit report anymore. Okay? And they don't show tax liens. They just show the recent debt that you haven't paid. Okay? So you can rebuild your credit, Linda. A lot of our clients don't care about that, but some of them want to, for whatever reason. If it may not make sense for you to rebuild your credit. Or maybe if you enrolled in Helps and you have a credit card or two that were smaller balance and you're going to keep those current, you can use those 2 credit cards or that 1 credit card, and you don't need a bunch of other credit cards, so you don't worry about rebuilding your credit up high. And then some Helps clients don't try to rebuild their credit consciously. It just goes up over time. Okay? Brian asks, Eric, I'm a Helps client. So I signed an entry of judgment in North Carolina and had two $60 payment plans set up with Smith Denham over a $6,000 Discover card. Have you heard of entry of judgment? Well, yeah. You may want to call Helps and talk to one of the attorneys. Maybe Kai said Helps. North Carolina has, you have to designate exemptions, can get a little complicated if someone has a judgment against you. So call and talk to us about that. One of the attorneys, and we'll go over that with you, how to do that. Give you some information on that. But you'll be fine. The credit card companies could still take me to court. Well, they could sue you, but you're not going to have to go to court, Sandra. Remember, if you owe the debt and you get sued, you don't have to go to court. They get a judgment. They'll eventually get a judgment, but you don't have to appear in court. And sometimes the lawsuit will say a certain date and time, and you'll think, oh, I have to go to court. Eric's wrong. No, if you read it carefully, that's only if you're going to contest or fight the lawsuit. If you owe the money, you don't need to contest or fight it. You do nothing. They get a judgment. End of story. They can't collect from you. Not true in my case. I joined 720. My score is stuck at 6 for over a year. I know that Phil says that it takes a year and a half to 2 years to rebuild it. A lot of our clients, 644 is not a good credit score, but it's not a bad credit score either. And I guess Roger's saying he rebuilt it. It was not too hard. If you follow Phil's program religiously, you should be able to rebuild your credit. Okay? But do you really need to is the other question. For quite a few while in Helps, I even have videos that talk about why why seniors don't need to worry about their credit scores, but some seniors do, and I understand that. Some people worry about, well, if I need to move, I need a good credit score for a landlord. Well, we have a letter called a landlord letter that explains to a prospective landlord if you have negative entries on your credit that no one can touch your social security or pension. It's protected, and that money will always be available to pay rent. And we found that to be helpful for helps clients that want to rent and give that letter to a prospective landlord. Jimmy says, Katrina, I did the steps and raised my score up over 700. I just got an Amazon card with a 400 limit from Synchrony Bank, which is one of the banks I defaulted on to account. So are you telling me, Jimmy, that you still owe Synchrony on those two cards, and then they've given you another card now after you rebuild your credit for $4,200? That's quite the story, if that's the case. I'd love to hear. Tell me about that. I'd like to talk to you on the phone later about that. That's curious. Um, yeah. So Kathy says I didn't join 720. And no reason to join. So it's up to you. No. Uh, the 720 credit score, 7 steps to a 720 credit score helps pays a fee. I pay him. We pay him a lump sum money each month to handle all our clients. Okay, and we've been doing that for several years now. So you don't pay a fee. The only way you'd pay him a fee is he may have a kind of a credit card or something that you can get, and it's a small amount. But no, you don't have to pay. But that's not necessary. You don't have to pay him any money to be part of that program. And you're right. A credit card is not a gift of money. You're exactly right, Roger. You've got to pay it. Um, okay. So this person contacts us from Illinois. My dad is a disabled veteran who served in Korea. Well, I kind of think maybe he served in Vietnam, but it could be Korea. I kind of doubt it. But he had a stroke in '05, and we're now struggling. We lost my mom. It's been rough. They go on. We're making it off his Social Security check of $2,500, and a mortgage right there is $1,400. So yes, we're lost. Two people, meaning two incomes, and one of them is the daughter. So it's the daughter writing for her dad. And she says, I am the one carrying all this weight and stress, and I need guidance. Thank you kindly. Okay, so we're going to call her back, and we probably already have, and told her, okay, you don't need to worry. You don't need to pay any of the dad's any of the dad's credit card debt. It's protected. Um, we can stop the creditors from harassing you. Even if they sued dad, you wouldn't have to pay him. Now, we may also be giving you some information. Your dad might be entitled to some benefits. It depends. There is a benefit for veterans that served during time of conflict called aid and attendance. We'll give you information on that. Brian asks, in your experience, at what amount owed does a debt collector normally sue? Well, there really isn't an amount. I mean, they sue for $1,500, $1,000 on up. Um, but the question is, how often do they sue? And not very often. Especially if you enroll in helps, they get a cease and desist letter. It's definitely less likely they would choose to sue. I used to I used to say maybe 1 out of 10 times you got sued, and then I've been admonished by the other attorneys that helps that I'm not to say that anymore. So I don't, because it could be more often than that. So don't. I didn't say that. You could be sued. It doesn't matter if you get sued. You get us a copy of the lawsuit. We don't need the first 2 or 3 pages. We're going to send a letter to the attorney who sued you. Let him know that your income's protected. You're not going to have to go to court. And we're going to always there to answer your questions, explain why you don't need to worry. So Jimmy says, yes, that's what happens. Did you hear that? Jimmy had two old Synchrony bank cards that he didn't pay, that he still owes money to. And then he rebuilt his credit, it sounds like maybe through 720, and Synchrony Bank gave him a credit card for over $4,000, even though he has two other credit cards he didn't pay. So Brian, Katrina says, I got sued by American Express for $630. I guess there is no minimum. That's pretty well on the low side, though. I think a lot of times the decision to sue is not made by a human being, but it's made by a computer. Maybe they have some criteria or some information that they feed in the computer and says, if we sue this type of person, we're more likely to collect. So let's sue them. Because it costs them money to sue. They have to pay a fee. Okay? Unfortunately, this person writes in, unfortunately, I'm not receiving my pension check since January. I don't know why, but he says, and I can't keep up with my bills. I have considered bankruptcy, would like to know which is the better choice, bankruptcy or helps. Well, we have videos that talk about bankruptcy versus helps. Bankruptcy is expensive. You can file bankruptcy. Sometimes bankruptcy can be like Brer Rabbit in the briar patch. It can get you into a mess if you file bankruptcy. But for a lot of times bankruptcy just doesn't make sense for seniors, and it's expensive. So we'll go over that, but we have videos that talk about that. I heard Discover always sue. I guess that's why I set up a payment plan. See, that's why they sue, Brian. They want the reputation to get out there that they sue, and so people will end up paying them no matter what when they don't have to pay them. That's why I tell our clients, no, if your income's protected, you don't need to pay Discover. Don't feed into their internal logic. Okay. This person writes us, and they say, I'm already a member of HELPS, now receiving late payment warnings from Liberty Bay Credit Union. I thought you sent them a cease and desist letter, along with all my other accounts. Well, okay, the Fair Debt Collection Practices Act prevents a debt collector from contacting you by phone or mail, okay? Not an original creditor. So Liberty Bay Credit Union is an original creditor. They can still send you a late payment or a bill. Normally they would stop calling you if they get one of our letters. Now there are 7 states at least that take the Fair Debt Collection Practices Act and incorporate it under state law so that you wouldn't get a contact from a state, from an original creditor on a debt. If we send a cease, but it's our experience that if we send a cease and desist letter to whoever you owe money, whether original creditor or a debt collector, and they're going to stop calling you on the phone, an original creditor may still send you a bill. Okay? Okay. I have turned in Sears Citibank. Shall I turn in Shell Citibank and American Airlines Citibank? I think you'll find that they're probably going to cut you off. If you have one Citibank you're not going to pay, the other ones will cut you off. Now, I guess if it's a gas card, keep using it and keep paying it. If you pay it off every month and there's not a big balance, and at some point you're going to use the credit card and it's going to be declined at the gas station. Just don't use it when you're on empty. Okay? But normally the computers with the banks on the credit cards, they have, they cross-reference. So if you don't pay one, they're going to cut the other one off. Interestingly enough, in bankruptcy, you file bankruptcy, all the credit cards shut you off whether you owe them anything or not. They all subscribe to a service, lets them know if one of their credit holders filed bankruptcy, and they shut you off. If a credit report says it's charged off, can they still sue? Yeah, they still can, and they do. They can turn it over to a debt collector to collect from you. If that happens, you just give it to helps. Now, that's why our representation is ongoing. It's not just one time. We represent you literally forever. So if you have a debt you can't pay, you get a new debt collection notice from a new collector, you give it to us. We're going to send a new cease and desist letter out to that new debt collector. I got a call from a debt collector yesterday regarding a medical bill. I've started to pay the bill, but not through the collector. Well, you can turn that in. If you're a member of Helps, Mary, you can turn that into Helps, and we'll send them a cease and desist letter, so they leave you alone. If you want to keep paying the medical bill, you can do that on your own. You can pay it directly to the medical provider. Should I continue to pay the bill and refer the debt to Helps? Well, you don't have to pay the bill. You can just refer it to Helps, and you don't pay it anymore. That's if you want it, you can. You don't have to. Sure, you can stop paying it. That's for Mary. She's asked, should I continue paying this bill and refer the debt that was turned over to a collection agency? But she'd been paying it to the original creditor, a doctor. She wants to know, should I still pay the bill and refer it to Helps? And you can, but you don't need to. You can just refer it to Helps and stop paying the bill if you want to. Is your firm going to sue those debt collectors for breaking the law? Yeah, we're in the process of gearing up to do that. We hired an attorney that we're training her so she can sue debt collectors. We're finding that there's not enough attorneys that sue these guys, and we need to sue them so that they'll follow the law. You got me concerned about living in North Carolina. Well, I'm glad you put LOL, because you don't need to be worried. See, different states have different proceedings for collecting debt. And sometimes the attorneys that get the judgments, they use those proceedings. Some of them are really crazy. Texas, they appoint a court-appointed receiver. And you get this scary letter in Texas once in a while from some guy from, I don't know what they call him, constable or something like that. And he says, I'm going to do this and that and the other thing to you. And, at the bottom it says, as allowed by the law. Well, you can't collect hardly anything from anyone in Texas. But, if you got that letter and you didn't understand the law, you'd be terrified. You'd be tempted to call them up on the phone and make arrangements to pay the debt. That's one reason we have these YouTube live videos, so we can tell you the law or tell you what the law says and give you information so you don't need to worry. You don't need to be taken advantage of. That's why I talk so much about debt management companies. No one else tells you that you don't have to pay the debt. National Council on Aging gets $50 million from the United States government every year. They don't tell you about it. Their mission is to help seniors, especially those that are struggling financially yet. In all their literature and all their websites, they steer you toward debt management instead of letting you know that your Social Security is protected. The seniors that have financial problems, they're the ones that have the debt, that have lower income. Okay? They're the ones that need to know what I'm talking about. I will say this. I am a little upset. It looks like there's a federal bureau called the Consumer Financial Protection Bureau. I think a lot of the banks have been upset with them. Uh, I don't know why. I mean, maybe they've gotten into areas they monitor the bank and sued banks for doing things that are wrong. Frankly, I thought they've done a wonderful service. SCFC Consumer CFPB Consumer Financial Protection Bureau. I read an article yesterday or something that 90% of their employees are being laid off, which is I don't think is a good thing. Uh, I just read an excellent article they did on student loans. We'll be talking later today with Jeff Hoyt for Senior Living about that, student loans. But anyway, um, this person contacts us from Texas. I'm being sued by Wells Fargo for a credit card debt. I'm on Social Security disability. I'm filing an answer on Monday. I have until the 14th. I'm going to answer. I do not have enough information to answer the allegations contained in the plaintiff's complaint. Can I write that if there's no box to check? Well, if I talk to this guy, he's on Social Security, and it looks like a little pension. If he owes the money, you don't need to file an answer at all. I mean, you can if you want. We don't help people do that. It's not what we do. But you don't need to worry about it. Brian says, I've been obsessed with the seizure of my furniture in a hospital bed. I haven't been sued or threatened. Oh, no, no, no. Don't worry about that, Brian. Don't you worry a bit. And if you start getting worried about that, you call on the phone and talk to one of the attorneys, and we'll assure you that's not going to happen. Okay? Well, they haven't been shut down completely, but hopefully they can still do their work. Okay, so this hour has flown by. Hard to believe. Okay, I've got some more things to talk about, but I'm going to pick up on those tomorrow. I want to thanks for your participating. There are a lot of questions today. Paleface says, you make it seem so seamless, but I don't think things are as simple as you say. There's probably some pitfalls along the way. I'm sorry, Paleface. I'm 74, attorney for 46 years, 30 to 40,000 bankruptcies, been doing helps for 12 since 2012. Was that 15 years now? Yeah. You know, it is seamless. I mean, I don't want to scare seniors when I don't need to scare them by making them worry. A lot of attorneys do that. Yeah, I don't talk about, outliers. I don't need to. If something happened that was really strange, we would know what to do. Okay? So no, it's basically this. Your Social Security, your pension, your retirement income is protected. There's a federal law in 2012 that protects twice the amount of your money, your federal benefits deposited in your bank account from garnishment by your bank without you having to do anything. It's not the practice of creditors to try to go after and take your home or your property, even if you have equity over and above the exemption in the state where you live. They don't do it. So why do you want me to make you worry? I don't want to make you worry when you don't have to. And if there was a problem, we know how to deal with it or tell you what to do. But no. So when I make it seamless, yeah, I don't want to do it any other way because I don't want to scare people when they don't need to be scared. Yeah. Phone number is 855-435-7787. Helps us or helps US. You can, Paleface, you can always call and talk to us, and we'll be glad to go over this with you. We've got our website. You could probably spend hours on it. You could watch our videos days on time. We've got hours and hours of videos. We have our YouTube live videos, and then we have videos on our regular YouTube. We have a lot of videos with senior living. Okay. It's the other situations. That's what helps does. We can talk to you about other situations. We talk to seniors about things about, timeshares, surrendering a car, a house payment, and maybe they're being foreclosed. I spent a half or 45 minutes yesterday. I'm going to be going over here for a second, talking to a guy I think it was in Virginia. Didn't have the internet. And it looks like he's being foreclosed, and there's a foreclosure sale next week. And he just was clueless on stuff, and I gave him 6 attorneys to call. I said, you got to call a local attorney and file a bankruptcy to stop that foreclosure, because you could lose the home, and he had a lot of equity in the home. You could lose that. And I told him, if you can't get one of those attorneys to help you, call back and we'll get you 6 more. Okay. So we do other things as well. We do these. So we just don't protect people from creditors. We'll help you in other areas. So thanks for participating today. Call if you have any questions, and I will talk to you tomorrow. God bless. Have a great day.